Good morning. This is Rajeshkumar. Today we are going to analyze one theory question on the rights of the third party. The video content has been made available for informational and educational purpose only. Kindly go through this page completely. Theory question: the right of action for third parties introduced by Section 1 of the Contracts Act 1999, that is, Rights of Third Parties Act, was unnecessary and so has proved unpopular. We are going to analyze this question. The Contracts Rights of Third Parties Act 1999 introduced significant reforms to the doctrine of privity of contract. It allows the third party to enforce certain rights under the contract in which they are not directly involved. This reform was aimed at addressing the rigidity of the privity doctrine, which traditionally prevented the third parties from claiming the benefits even when a contract was intended to benefit them. This reform was aimed at addressing the rigidity of the privity doctrine, which traditionally prevented third parties from claiming benefits, even when a contract was intended to benefit them. Despite its practical utility, the critics argue that the act was unnecessary and unpopular, suggesting that common law mechanism already provided sufficient means to navigate around privity. In this analysis, I will critically examine whether the right of action for the third parties under the Section 1 of the Act was truly needed and whether it has proved to be unpopular. The doctrine of privity is rooted in cases such as Tweedle versus Atkinson in 1861, which held that only parties to a contract could sue to enforce it. This led to the harsh outcomes, particularly where contracting parties intended to benefit third parties, such as in Dunlop Pneumatic Tire Co. Limited versus Selfridge Co. Limited in 1915, where Dunlop could not enforce its contract against a third party, even though the terms were meant to benefit them. Historically, the court attempted to circumvent the rigid application of privity through legal devices such as the trust of a promise and collateral contracts. But these methods were not always successful or sufficient. The judicial development of these exceptions led to significant complexity and unpredictability. This unpredictability became the primary motivation for reforms, resulting in Contracts Rights of Third Parties Act 1999. Under Section 1(1), the Act allows a third party to enforce a term of contract if the contract expressly provides for it or if the contract purports to confer a benefit on the third party, unless the contracting parties explicitly exclude such rights. This marks a departure from the rigid common law rule that a third party could not benefit from or enforce a contract as seen in Beswick versus Beswick in 1968. The widow in Beswick only succeeded in enforcing the contract after being appointed a administratrix of the estate, underscoring the limitations of the common law. The Act simplifies the third party enforcement by removing the need for convoluted legal devices like trust or collateral contracts, providing a more straightforward route for a third party beneficiaries to enforce their rights. Was the reform necessary? Critics of the Act argue that it was unnecessary as the court had already developed mechanisms to sidestep the privity doctrine. However, these mechanisms were often unreliable and inconsistent. For example, in Scrutons Limited versus Midland Silicons Limited in 1962, the House of Lords rejected the argument that an exemption class could benefit a third party due to the lack of agency. This decision highlighted the insufficiency of common law devices to consistently protect the third party. Additionally, New Zealand Shipping Co. Limited versus AIM Satterthwaite Co. Limited in 1975, the case showed that while Himalaya classes could sometimes offer protection to third parties, their applicability was limited and complex. It requires a specific contractual provisions. These cases reveals that common law was not equipped to provide a simple, consistent solution to private issues, justifying the need for statutory reform. Why it is of unpopularity of the act? Some argue that the act has proved unpopular, pointing to the limited number of high-profile cases in which it has been applied. However, this does not necessarily indicate that the act is ineffective or unnecessary. Many contractors today explicitly exclude the application of 1999 Act as business may prefer to maintain control over the enforcement of the contractual terms. This exclusion is permissible under the Section 1(2) of the Act, which allows the parties to rebut the presumption that a third party may benefit from or enforce a contract term. Nevertheless, when the Act has been applied, it has provided significant benefits. In Nation Shipping Co. Limited versus Cleves and Co. Limited in 2003, the court allowed a chartering broker to recover commission under the 1999 Act, emphasizing that it effectively fills the gap left by common law devices. Similarly, in Chudley versus Clydesdale Bank PLC in 2019, the court upheld the right of the third party investors to claim under a contract even though they were not expressly named. Let's move on to the necessity of the reform, the traditional privity doctrine. The doctrine of privity, a long-standing principle in English contract law, holds that only parties to a contract can enforce it, with third parties generally having no rights under it. This doctrine, though well established, led to perceived injustice in certain situations, particularly when the third parties were clearly intended to benefit from a contract but lacked any enforceable right. One key example is found in Twiddle versus Atkinson, where a son could not enforce a contract made for his benefit between his father and his father in law due to his lack of privacy. Similarly, in Dunlop Pneumatic Tire Co. Limited as a Self-Bridge Co. Limited, Dunlop as a manufacturer could not enforce the contractual price condition on a third-party retailer, even though the terms were intended to control the resale prices in the supply chain. These cases highlighted the restrictive nature of the privity, often leaving the third parties without a remedy despite the contracting parties' clear intent to benefit them. What are the common law exceptions and limitations? To address some of these perceived injustice, the common law developed exceptions that allowed certain third parties limited rights. For instance, the trust of contractual promises could be used to enforce the third party benefits as seen in Beswick versus Beswick, where a widow was able to enforce her husband's contract with his nephew by arguing that it created a trust in her favor. Similarly, agency principles allowed the third party beneficiaries to enforce certain contracts. if an agent acted on their behalf. However, these exceptions were often complex, creating uncertainty and inconsistency in their application. Another workaround was collateral contracts, where a separate contract was inferred to give the third parties some level of enforcement rights. However, this approach was criticized as artificial and convoluted, often depending on judicial willingness to construe the existence of such collateral agreements. These exceptions, while providing some remedies, were generally insufficient for resolving the fundamental issues of the third party rights in contracts, which led to calls for the legislative reform. So, what are the legislative reforms on the Law Commission report? The Law Commission report preceding the Act noted the limitations of these common law exceptions and argued that the lack of third party rights led to unfair outcomes. The Commission recommended reform to enable the third parties were expressly identified or otherwise clearly intended as beneficiaries to enforce the contracts in their favor. This led to the enactment of the Contract Rights of the Third Party Act 1999, with Section 1 establishing a clear statutory right for the third parties to enforce contractual terms provided certain conditions are met. Thus, the reform aimed to simplify the third party rights, moving away from the complexity of the common law exceptions. Section 1 allows the third parties to enforce terms if 1. The contract expressly provide for it, or 2. The terms purports to confer a benefit on the third party. This represents a departure from the restrictive privity doctrine, enabling more straightforward enforcement of the third party rights. Let's examine the popularity of the Section 1. The requirement and conditions of the Section 1 are: it sets clear requirement for the third party enforcement, primarily a need for explicit reference to the third party or an intended benefit. This section has been upheld in cases like Nishin Shipping Co. Limited versus Cleves and Co. Limited, where the court allowed a third party broker to enforce a commission class as it satisfied the statutory requirements of conferring a benefit. Similarly, in Avra Commodities versus Cito, a third party was allowed to enforce a contractual term as it was explicitly intended to benefit them, demonstrating that the Act provides enforceable rights in line with its conditions. However, the Act does not universally grant the enforcement right to all the third parties. It respects the autonomy of the contracting parties, allowing them to expressly exclude the third party rights if they wish. Additionally, while the Act grants the third parties the right to enforce, it also includes limitations that prevent them from varying or resigning the terms unless they obtain the consent of the contracting parties. This balance seeks to preserve the contractual freedom while allowing the targeted enforcement by intended third party beneficiaries. The popularities and criticisms. While Section 1 has been effective in certain cases, it has not been widely used, leading some to argue that it has not achieved the widespread popularity. One possible reason is that the contracting parties may still be cautious about the potential for unintended third party claims and may prefer to exclude the third party rights to avoid unforeseen liabilities. Moreover, the parties might avoid relying on the Act in favor of the established contract structures that do not involve the third party enforcement, which can lead to a greater certainty and control over the contractual terms. Some critics suggest that the Act's requirements, particularly the need for an express mention or clear benefit, limits its utility. For instance, if a contract does not specify a third party beneficiary, or if the benefit to the third party is ambiguous, the enforcement may be denied, as in the case of Prudential Assurance Co. Limited versus Iris. This case, where the ambiguity over third party benefit led to enforcement being denied. Such outcomes may deter the parties from relying on the Act, contributing to the limited application. Furthermore, the Act does not apply universally to all the contracts, as some types, like employment contracts, are expressly excluded. Thus, this has led to the additional complexity, as parties and courts must navigate a mixed regime of statutory and common law rules for the third party rights. Finally, was the reform unnecessary? On balance, the Contract Rights of the Third Party Act 1999 address clear deficiencies in the common law treatment of third party rights, streamlining the enforcement for certain third parties in ways that the prior exceptions did not. While the Act may not have led to a surge in third party enforcement actions, it has provided a practical mechanism for those cases where contracting parties intended to benefit the third party. However, the popularity is limited, perhaps due to the cautious drafting by the parties seeking to avoid unintended third-party claims. Its impact has been meaningful but not transformative, and it operates alongside existing doctrine rather than replacing them. Thus, while the reform was necessary to address the gaps in privity, the perceived unpopularity of the Section 1 reflects a balanced legislative measures rather than an outright failure. The act was needed adjustment to the rigid privacy doctrine, offering the targeted solutions without drastically reshaping the contractual principles. Let's conclude. While there is some criticism regarding the necessity and the popularity of the Contracts Rights of Third Party Act 1999, the Act provides a clear and effective mechanism for the third party enforcement of contracts. So, the limitations of the common law devices prior to the Act's enactment justify its introduction, and the Act has been successfully applied in the cases where it would have been difficult for the third parties to claim without it. Though the contracting parties may choose to exclude the application of the Act, it provides a remain valuable in context where the third party enforcement is intended. Hence, the reform was necessary and its perceived unpopularity does not diminish its importance. Thank you.